welcome to the club. This is really, really good news.
We're the Armed Attorneys. We are talking about some breaking 2A news with regard to the Supreme Court and some cases that have been reversed and remanded for further review. But before we begin, show your support for the Second Amendment by hitting that like button, and welcome back, Miss Emily Taylor. Hey, Emily, welcome.
Hi, thank you, Richard.
Man, I'm glad nothing has happened in the 2A world since you've been on maternity leave.
Right, I was out a month. My baby's a month old, and we've got Uvalde, we've got Bruen, and we've got gun control passing. I know, like, what a month for me to be out of pocket, but here we are.
Yeah, I'll say it's been kind of quiet for a couple of years. And then, oh, man.
I know it.
So you picked a heck of a time to get out of here. But, you know, what we're talking about today is, you know, on the heels of this extremely, landmark case, New York State Rifle and Pistol Association v. Bruen, we've set up this new standard by which Second Amendment cases they need to be evaluated. It's a one-step test that Justice Thomas laid out. Incredible, incredible, incredible. Now, the end of the Supreme Court term is fast approaching, and there were some other 2A cases pending. And in light of Bruen, what's happened to these cases, Emily?
Yeah, so we have cases that are being sent back down to lower courts to be decided in light of this new standard that Bruen says has to be applied to laws that may infringe upon the Second Amendment. And so we'll go through them in a little bit more detail, but essentially we've got a licensing case, very much in the vein of Bruen. We've got 2 high-capacity magazine ban cases and 1 case about, you know, quote-unquote, assault weapons. So let's just talk through briefly what's going back down to the courts. It's great because this really kind of runs the gamut of 2A infringements, right? Licensing, high-capacity assault weapons.
Yeah.
So when we see these, you know, hopefully struck down as violations of the Second Amendment, we're really doing well in terms of anti-gun legislation.
Yeah, and that's been one of my favorite pastimes so far, you know, since we got the Bruen decision and going through the comments here, and we just see all these different little infringements pop up, red flag here, or, you know, prohibited persons here, or sensitive places, you know, all the different infringements that we see, and just people saying, under Bruen, how could this stand? Under Bruen, how could this stand? And it's really fun because, you know, it is a high standard the court has set. And we're going to see some immediate action on some of these issues immediately. So the first one that we have, it comes from the New Jersey Rifle Association v. BRUCK, and this deals with their high-capacity magazine ban. Prior to this, New Jersey had a ban or limitation on magazines that could hold more than 15 cartridges, more than 15 rounds of ammunition. They bumped that down to 10, and which is just so restrictive, and that's where we get this case. Now, what did the courts do in this case, Emily?
Yeah, so what the Court of Appeals did was uphold this 10 capacity magazine limit under an intermediate scrutiny test, which now under Bruen we know you cannot, not only can you not evaluate under intermediate scrutiny, you can't even evaluate under strict scrutiny, right? So, we have a much more friendly test to the fact that this is a constitutional amendment. It's a right that we have as citizens.
Yep.
And so the people of New Jersey actually are going to have a pretty good day here, because not only do we have high capacity magazine ban hopefully going away for them, but also for the first time ever, New Jerseyans are going to be able to be issued licenses, you know, presumably post Bruen. So, man, New Jersey, your world is about to change quite a bit.
Yeah, and this, you know, the court in that case used kind of a 2-step, you know, does this, you know, burden the Second Amendment, and then they're applying the scrutiny. And for folks, I'm sure you haven't missed this, but in case you did, we got to remind the new standard, it is a 1-step test. If the conduct presumptively falls under the Second Amendment, it will be based on the government. There's a presumption that it violates the Second Amendment, and then the government has to demonstrate that, you know, based on the text of the Second Amendment, informed by history and tradition, that regulation in this area would have been permissible. And there's only a few analogies in areas that it seems like they would be allowed to regulate. So high capacity magazines, can you imagine that surviving? No. So I think that brings us on to our next case, which is Young v. Hawaii. That's out of the Ninth Circuit Court of Appeals. This is very, very similar to our New York State Rifle and Pistol Association v. Bruen case, wouldn't you say?
It is. And if there is anyone who has it worse than New Jersey, it's people who live in Hawaii. It really is. The Second Amendment is virtually non-existent in Hawaii. And so, we had this case in which the Court of Appeals had said, basically, sure, you can completely restrict licensing. In fact, I believe that Hawaii wanted you to be of good moral character and engaged in the protection of life and property and demonstrate an urgency or need to carry a firearm. It was just an incredible standard that meant 0 licenses were issued in the state of Hawaii. Again, we're looking at a very similar law to what was struck down under Bruen. Again, they applied intermediate scrutiny, and we can't do that. So we should see licenses in Hawaii upcoming.
Yes. And, we've heard this out of Illinois and New York and in Hawaii already, saying, hey, we're just going to move things around, and, maybe the Supreme Court won't buy it this time. I don't see that happening either. But that brings us on to our third case, which is Duncan V Banta. This is out of the Ninth Circuit Court of Appeals. It originated out of California, and it relates to the large capacity magazines. Again, we're talking about similar issues like we had in New Jersey. Now, in this case, we actually got a pretty good district court ruling. We had Judge Benitez.
Yeah, Southern District of California.
Yeah, St. Benitez gave a great, well-reasoned opinion on why this violated the Second Amendment, but when it made its way up to the Ninth Circuit, it eventually worked its way to where it finally landed before going to the Supreme Court. They said, they upheld the ban, applying, again, intermediate scrutiny. And so, again, this is very similar to what we just talked about in New Jersey. I can't imagine that surviving. And that brings us to kind of our last case. And what is that, Emily?
Yeah, so that is BIANCHI versus FROSH. And this is a case that arises out of Maryland. And interestingly, this is actually an assault weapons ban case, which those of you who live in Maryland or have to deal with Maryland, I'm sure you already know, Maryland has an incredibly long and detailed list of banned firearms. It is horrendous. You can't even memorize it. You can't rattle them off. It is just an incredibly long, restrictive list. And we have here, a challenge to assault weapons bans. Again, applying the Bruen standard. I do not know how Maryland gets to continue to ban all these weapons under Bruen, given that we have, again, no more intermediate scrutiny, which is how this was upheld in the first place.
Yep.
I don't know. What do you think?
No, I can't see it, because what we got out of the New York State Rifle and Pistol Association case, going back to that analogous, regulation at the time, were based on what the court talked about in its opinion, we're really pigeonholed into kind of 3 areas. One is maybe a sensitive places argument. So we got that. Our prohibited peoples argument. We got that. And then they had a third decision, or a third kind of component related to bonding, which we don't really see that anymore. But they brought it up. Historically, there's some kind of bonding system for people carrying firearms, or, peaceable, sometimes you hear that called a peace bond. Carrying in a way that you aren't going to be terrorizing or disruptive or think disorderly conduct or think about that. So, those are kind of 3 areas we see them regulating. But the types of firearms, especially when we're talking in the context of assault weapons, we just don't see that coming up, and I can't see them overcoming that hurdle.
No, this is, and of course, y'all all know already that Rich and I are down here in the great state of Texas, in which we are virtually unburdened in terms of our Second Amendment rights. However, this is a great day. I mean, we've got some of our most restrictive states here: Hawaii, Maryland, New Jersey, and California, and of course, New York, right, from Bruen. You guys have had it tough. Welcome to the club. This is really, really good news.
And we got one last question that this, popped up in the comments section, and it would apply to these cases especially. And they say, hey, are these laws unconstitutional today? These cases got vacated, their orders vacated, remanded back down to the lower courts. Are these unconstitutional based on what we know today? And the answer is no. They're still technically the law, because we still have to go through that judicial process of the courts reviewing them, applying this new standard, and then entering orders. So I think it's hopeful, but we still have to stay, watch, be vigilant, and see what the final outcomes are. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
Yep, and I'm glad to be back, everybody. Please continue to leave us questions, comments below. We love to see them. I've been reading them all month while I've been out on leave. Until next time, we're the Armed Attorneys.